The House Criminal Justice Committee will come to order. Would the clerk please take the attendance?
Chair Hope. Here. Representatives Andrews.
Here.
Carter.
Present.
Breen. Young. Here. Arbit.
Here.
Devendorf. Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat. Harris.
Here.
Begol.
Here.
Madam Chair, you have 10 members present. You do have a quorum.
Thank you, Madam Clerk. Representative Cerniglu moves to adopt the minutes from the June 22nd meeting. Without objection, the minutes are adopted. And we will now take testimony on House Bills 4638, 4639, 4640, 4641, 4642, and 4643. And we have a gentleman on Zoom who will be testifying in support of the changes to the Children's Ombudsman's Office as proposed by this legislation based on recommendation by the Juvenile Justice Task Force. Good morning.
Good morning.
Go ahead and get
Madam
started
Chair.
whenever you're ready. Thank you.
Thank you. Good morning, Madam Chair and esteemed members of the committee. My name is Ryan Spidell. I am Michigan's Children's Ombudsman, and as you heard, I'm here today to speak specifically on House Bill 4638. I will mention 39 through 43 as well, and I would like to speak with you about what I believe those bills will do for Michigan's children, and also why I support 4638. And I think the most important thing is to first provide a little bit of a description as to what this office does as the Office of Child Ombudsman. So I'm going to take about a 40,000-foot view. I pulled 3 slides from a larger presentation I give to stakeholders around the state. You had MACP come in and testify last Tuesday. That's one of the entities I've testified or spoke in front of. I give this to MDHHS, prosecutors, and other individuals involved in child welfare. But as you can see, the mission and role of the Office of Children's Ombudsman in general is to help improve Michigan's child welfare system. So how do we do that? We look to our act, and our act asks us to have awareness, provide awareness, advocacy, public education, ensuring compliance with law, procedure, and policy, as well as review, or what we know as investigate, and make recommendations. And ultimately, the goal is to advocate for children and identify areas of improvement in the child welfare system. Just to speak a little bit about the authority and powers that I have as Michigan's Children's Ombudsman, I spoke about advocacy. So specifically, I can advocate on behalf of children to the legislature. Public education. Our staff takes hundreds of phone calls a year, and we describe the child welfare process in general. We also provide information to individuals that call us about how to contact MDHHS, who at MDHHS to contact, how to wade through the very large organization that is MDHHS. We also conduct investigations or reviews of cases, specifically in child protective services, adoption, and foster care. Within those cases, in real time, we attempt to ensure compliance with law, policy, and procedure. We pick up the phone, and when we see something, we say something. Ultimately, our investigations can result in what we call a finding. With those findings, I have to have a recommendation. A finding is defined in our act, and it's similar to if the ombudsman feels that something needs to change, or the ombudsman wants the department or an agency contracted the department for these services to explain the administrative action that they took. And ultimately, we're trying to effect positive changes in policy, procedure, and rules and law. And the biggest thing I want to express to this group is that we're not a regulatory body. These are recommendations. These entities know their business practices better than we do. And essentially, MDHHS is the expert when it comes to child welfare in this state. We also don't conduct criminal investigations. In fact, if we find something criminal, we have to immediately turn it over to the Attorney General or the county prosecutor in which it occurred. And a little bit about my responsibilities. I am required to issue an annual report. That annual report has to come to you, the legislature. It also has to go to the governor and to MDHHS. And in those annual reports, we list recommendations of things that we saw throughout the year. So you get it in our findings and recommendations, but you also get it in the annual report. We're also responsible for reviewing child death alerts that come to our office. And there's specific parameters that have to be met in order for us to investigate. And we take a look back at what has occurred in the previous 2 years prior to the death and the interaction with MDHHS. I want to speak a little bit about our confidentiality. The Office of Children's Ombudsman, our records are specifically exempt from the Freedom of Information Act. They're highly confidential records. Our records are not subject to court order. They're not subject to subpoena. So if MSP were to walk into our doors with a search warrant, that's something that we would have to entertain. However, that's a court order that we're not subject to. And the purpose behind this, our complainants, specifically in our act, are held very confidential. I cannot disclose the identity of a complainant without their permission. We also want to keep our witnesses confidential. If you can imagine a reporter that has a source of information and that reporter is reporting out on what that source is giving them, if that reporter had to provide the source's name and information at the end of their article, the reporter probably would not have any sources of information to give. I'd like to switch now and speak about House Bill 4638. As you're aware, the Juvenile Justice Task Force issued a final report after approximately 10 months of conducting research on the juvenile justice system and interviewing those involved in that system. Out of the research, the task force issued a final report on actionable recommendations to reform Michigan's juvenile justice system. They had 32 recommendations. Specifically, recommendation number 27 received a unanimous vote. This recommendation was to create an independent ombudsman or to strengthen the existing office to handle complaints and investigating administrative actions of juvenile justice facilities. The second part of that recommendation was to strengthen the confidentiality surrounding children and families that complain to the ombudsman or child advocate. The result is House Bill 4638 through 4643. I do want to mention that House Bills 4639 through 43 changed the name of the ombudsman to the child advocate. And this would be in acts such as the Social Welfare Act and the Child Protection Law, the Child Caring Organizations Act. Specifically, House Bill 4638, it changes the name of the ombudsman to child advocate. It defines residential facilities for the purposes of the act. It strengthens requirements for residential facilities providing JJ services, juvenile justice services, to provide a resident anonymity, privacy, and requires that facilities have procedures in place to accommodate the child advocate for interviews. It requires these facilities to post information about the existence of our office and how to contact us. It also provides the child advocate with the authority to conduct the same type of administrative investigations it currently conducts, however, extending this authority to residential facilities that provide juvenile justice services. So I want to just define what juvenile justice services is. It's defined in the Social Welfare Act, and in summary, it's a service outside of the judicial functions that are provided by a county for juveniles who are likely to come into the court's jurisdiction for various reasons, including delinquency or criminality. If the juvenile is placed into a facility, the term services specifically means intake, detention alternatives, probation, foster care, diagnostic evaluation and treatment, shelter care, or any other service approved by the county or county juvenile agency as applicable, including prevention, diversionary, and protective services. So if you can envision what a complaint might look like that would come into the office of the child advocate, a parent at home finds out that their child has been taken into custody by the police and lodged at a juvenile detention center. That parent might go into the residential facility as defined in this bill and read our sign. The parent may also hear the court-ordered diversionary services to keep this child or to help get this child into the home so the parents can care for the child, not the juvenile detention facility. This has to be done by a certain date. Say that date has come and passed. The parent remembers our poster and calls our office to file a complaint, worried that their child is not receiving the court-ordered diversionary services. This bill would allow the child advocate to investigate that, investigate the claim, investigate the court orders, look into facility records, see if any diversionary programs were offered, or what exactly is happening with this juvenile. If those things are present and they're happening, and maybe the parent doesn't know about it, we can inform that parent about what is occurring. And if the detention facility is not providing those services, we can advocate for the children to receive those services. Say in the same case, a judge that oversees juvenile justice services, the individual judge that ordered those services, they want to know, are these things being given? The judge can file a complaint with our office. And while I can't give the judge records or the parent records, I can inform them about our investigation and what we discovered. Ultimately, over time, the child advocate will start to develop data and can explore system-wide issues to inform the public, the governor, and the legislature. There is a new term introduced in this act under this bill that's new to this act specifically, and it's the term mediate. We do this regularly here at the Office of Children's Ombudsman. We attempt to mediate issues currently, and this just codifies that into our law. That goes hand in hand with ensuring compliance with law, policy, and procedure. All of this brings me back to the renaming of the office. The name Ombudsman is Swedish. Depending on where you look, it came about in 1552 or 1809. And from its roots, it means a representative of the community that goes before the king or queen to resolve issues or to the government in place. It was widely, and it is still widely popular in Europe and in Canada. The Children's Ombudsman in Michigan has a slightly different role and acts like an advocate in many cases. As I stated before, the law allows the Children's Ombudsman to advocate on behalf of children with the legislature. I believe the term ombudsman is outdated and is often confusing to the public. I do believe that if you say the term advocate, most people in the public generally know what you're speaking about. I did want to touch base. I witnessed the testimony and the questions last Tuesday on these bills, and there was a question about funding. And I just wanted to bring up to this committee that our office is specifically 100% general funded. So there is an ask in the current budget for FY24, and we are expected to hopefully hire 8 new FTEs to take on this large project. I support this bill, and I believe it'll be transformational for what our office can do for Michigan's children. We currently do this for child welfare, and it'll allow us to have authority to look into things that oversee and care for some of our state's most vulnerable children. We'll provide the advocate with authorities to shed some light and to help mediate administrative issues within juvenile justice facilities so policy, procedure, and lawmakers can make more informed decisions. I thank you for having me here to speak this morning. And of course, I want to open it up to see if anybody has any questions for me that I can hopefully answer.
Thank you for that comprehensive testimony. We do have a question from Representative Filler.
Chair, I have 2 quick questions with your permission, and I'll be quick. I thought you did a pretty nice job of describing the bill. We always ask the question, what are we fixing here? And, what problem are we fixing in House committee? And I guess you would argue that this sort of expands your reach to advocate for children, maybe to a little more investigative power. Can you just expound on, exactly why we need the bill?
Yes, absolutely. So I was the deputy director at the Office of Children's Ombudsman when the Coalition for State Governments, who was the entity that did the research and interviews for the task force, came to us, and they spoke to us about their findings. And what they found is that when they spoke with children, with family members, they often found that most of these facilities are owned and operated by private agencies or private nonprofits, counties, and they're operated by the counties or the courts. And oftentimes, when they express complaints, they fall on deaf ears. And these are already individuals that feel and believe that they have no name and no face within government, even locally. I believe that this bill accomplishes the task of giving them that voice. They can come to a state agency, an agency that can advocate from within state government for them. We're able to get down into the weeds, into the individual cases. And if there's the administrative act that isn't happening and we believe it should be, that's something that we can recommend. If it's an administrative act or a procedure that should be happening and it's not, we can advocate with that agency to make it happen in the best interest of children, Representative Filler. And really, we are currently just have authority over child protective services, foster care, adoption, and then the entities that provide those services, such as foster care and adoption, the private foster care placing agencies. This would expand that to juvenile justice. Right now, we do have limited authority for juvenile justice. It's if the individual is a dual ward, so child welfare ward or juvenile justice ward, and they are given to the Department of Health and Human Services as a ward to care for. These individuals in juvenile justice don't meet those criteria. They are just juvenile justice wards, and they're under the supervision of the court or the county in these juvenile justice facilities. There is no one body that oversees or investigates any of these things. Each county is left up to their own. There are two specific state entities that are owned by the state and operated by the state that receive juvenile justice wards. However, the bulk of them are run by either private nonprofits, counties, or courts.
Thank you. And I presume you're going to have to hire new individuals and have some additional costs under this legislation. Do you have any idea how much and how many people you're going to hire?
I do, absolutely. So we didn't want to overshoot it, but we definitely didn't want to undershoot it. We currently have 4 investigators. There's only 14 of us right now, and I have 3 intake staff. We're short a couple people. However, with the knowledge that we're going to be hanging posters, and there's also some funding provided for public service announcements, we anticipate an increase of calls and electronic complaints to our office. So we would like to increase our intake staff and double our investigation staff. So right now we have 2 units. We have the public education and intake unit, which essentially has essentially 4 people. And then we have the investigative unit, which has 4 people plus a manager. We would move to have 3 units, 2 investigative ones and 1 intake unit, expanding that intake unit. We would also have a technical specialist that would allow us to aggregate our data and hopefully delve into social media and update our website regularly internally, so we can start sharing more information so it's readily available on general information that we can provide. And when we sat down with human resources and finance at DTMB, we came up with a number of $1.6 million. So it is a small drop in the bucket for the budget as a whole. We do believe that that will give us the funding necessary to expand our FTEs, 8 people, as well as our physical footprint. We do spend some time in the office, so we need space for those people. But this is also going to be a big task for me as the ombudsman or new child advocate, because these places will not know this new law and what it requires them to do. So there's going to be a lot of relationship building that occurs. There's going to be a lot of information that our office is going to have to travel the state and provide over the next year or 2.
Thank you, sir. I don't see any more questions. We appreciate your testimony this morning. We do have a card. On bills 4638 through 4643, Trevor Van Dyke, representing the SCAO, supports the bill, does not wish to speak. We'll now take testimony on Senate Bills 134 and 135. And here to testify in support, we have Garrett Wheat from Senator Ruth Johnson's office and Judge Harvey Hoffman. I'm so sorry. I know that. I know better.
I've been called much worse.
Thank you, Madam Chair. Appreciate the opportunity to present these bills to the committee this morning. We also want to thank Senator Kevin Hertel, who's been working on this legislation with Senator Johnson. Senate Bills 134 and 135 would seek to expand access to the successful Ignition Interlock program currently used by our state's sobriety courts to other specialty courts in our state. Research has shown that the Ignition Interlock program is more effective in reducing DUI recidivism than license suspension alone, and research has also shown that Ignition Interlock programs help to reduce DUI-related crashes and fatalities. This is an issue that Ruth worked on passionately when she was Secretary of State as our state's Chief Traffic Safety Officer. And under her tenure, we also made some updates to strengthen that program, including requiring a camera capable of recording a digital image of the individual providing the sample, as well as random retests while individuals are driving. Under the current law, the Ignition Interlock program can only be utilized by judges in our state's DWI sobriety courts. These bills would allow other specialty courts in the state to also utilize this program when it is appropriate for a particular defendant. This would include Michigan's drug treatment courts, our mental health courts, and our veterans treatment courts. This would allow more individuals to have a legal path to restore their driving privileges while also protecting other motorists and pedestrians from harm. We want to say a special thank you to Judge Harvey Hoffman and to the Michigan Association of Treatment Court Professionals who have worked closely with us on this legislation. We're proud to have a number of bipartisan sponsors on these bills, which both passed the Senate unanimously. And again, I want to thank the committee for taking them up this morning, and I have Judge Hoffman here with me as well if members have any details that they would like on the specialty courts or the program. Thank you.
We do have a question from Representative Breen.
Thank you, Madam Chair. Big fan of the specialty courts. Thank you. My questions pertain to costs and what remedies are available if the locks malfunction. I've heard some stories, I'm sure everybody has, about these items. If they malfunction, I want to make sure that there's some type of a course that somebody could take. Just as an example, a neighbor, her device malfunctioned. She could not get into her car. She could not get her kids to daycare. She ended up missing work. And there were some very high fees that were associated. What can you tell us about fees, if any, at this point, and what options exist for somebody who has a malfunctioning device?
Okay, thank you. I'm happy to address that. I'm retired from the bench now. I spent 20 years on the treatment court bench, specifically starting with the DWI court. So I've worked with this stuff quite a bit. In terms of expenses that are involved, I guess you have to look at it from a couple different levels. There is obviously an expense for the individual because they have to get a license, get insurance, and maintain their car. There is no funding, state funding to assist in that. So I guess that's probably where the greatest amount of expense lies, is that the person has to get the interlock, pay for that, and pay for getting their insurance so they can drive. There is no expense cost to the court. I mean, it doesn't change our work any. It makes it somewhat easier because people can now drive to work, drive to school, drive to court, drive to probation, drive to treatment. And while there is an increase in workload for the Secretary of State because obviously there'll be more people in the program getting licenses and so on, I haven't seen anything from the Secretary of State where they feel any additional funding is required. Now, going to the specific question, the second question that you asked, dealing with what happens when something goes wrong. I can speak from the court's perspective. Treatment courts are like any other court. We use due process. If a person has or is in one of our treatment courts, if they've got the interlock on the car and there is an issue with it, that it doesn't work, there's some sort of malfunction, they certainly have the right, before there be any sanction or anything provided through the court, to have a hearing. And if they like, they can have an attorney there for the hearing. We have found these programs are extremely are successful because they are so popular, because we find that people want to be able to drive and be able to have a better life. Now, I can't speak specifically to what might happen if they wind up going to a hearing to the Secretary of State. I have heard, probably the same that you have, that there have been situations where it's been a difficult situation for the person. But I can't speak to what would happen when they find themselves in the wheels of bureaucracy rather than the wheels of the court.
And I would just add, and I worked with Senator Johnson during her second term as Secretary of State as well in the executive office. So I can't speak for the current Secretary of State, but I know when we were there, we took those complaints very seriously. I remember we actually completely removed one of the vendors that had repeated issues. And so I know when we were there, we did try to work with people when they had those issues. We took them very seriously, and we took them back to vendors.
Thank you, I appreciate
Yeah.
that. I was more concerned with what you just mentioned about the vendor.
Yeah.
Because the installation fee, and then there were monthly fees associated with the device. And I want to make sure that it's still available for people who might not have those financial means. And that could be absolutely a discussion for a later time. I do support the bills. It's just something I want to make sure that the bill sponsors and the courts are aware of for these individual expenses and people that want to participate in treatment courts but find it hard to overcome some of those hurdles. But thank you.
Yeah, and on the fees, I know Senator Johnson likes the current system where the taxpayer's not paying that fee. It would be the individual who had the DUIs that would pay those fees to have it. But I think the intent is, as you mentioned, that way they can potentially, have a job and go and earn an income and take their children to school and do things like that. So that's the intent, but the burden is on them.
But the other thing is it's a public safety thing too. As I think most of you know, the interlock means that if they want to drive their car, they have to breathe into the machine, and if there's alcohol on their breath, the car won't start. And these people are all repeat drunk drivers. So we looked at it as certainly wanting to help our people, wanting to have them get on with their lives and succeed in their programs. We had research done that having the interlock on the car and having the license, there was only like 1/3 as many new violations as people who were on standard probation. So it's both a public safety thing and helping people get on with their lives in a more positive way.
And just so we're all clear, this is a program that already is in place. These bills expand the availability of this as a tool.
Yes,
Correct.
It's been around for about 15 years, and matter of fact, it's made the DWI courts explode across the state, particularly in the rural areas, like in the UP and in the North Country. We've been able to cluster them like 4 or 5 courts in one program because people can now drive to court, they can drive to probation, they can drive to treatment, and it's probably one of the major things as far as why we're one of the leading states in the country as far as the DWI courts.
Thank you very much. I don't see any other questions. I'll take this opportunity to read in cards. Trevor Van Dyke from Scale supports Senate Bill 134 and 135. Does not wish to speak. Nathan Triplett from the State Bar of Michigan supports SB 134 and 135. Does not wish to speak. Brandon Lanyon from the Prosecuting Attorneys Association of Michigan supports Senate Bills 134 and 135 and does not wish to speak. And I'll take a motion from Representative Filler to report SB 134 with recommendation. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat, Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. Senate Bill 134 is reported with recommendation.
Thank you. I'll take a motion on Senate Bill 135 to report from Representative Young. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat, Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. Senate Bill 135 is reported with recommendation.
Thank you. Representative Arbit moves to excuse absent members. There being no objection, the motion prevails by unanimous consent. And there being no further business before the committee will stand adjourned.